Hello again, and welcome to the last session of this year's risk management and insurance module. In this session, we'll deal with the assignment. As I indicated in the first session, I will not give you the answers, but I'll just take you through what we are looking for from you in answering the assignment. Just got a one slide presentation, which I'm going to bring up. Apologies while I just bring up my presentation. There's just a few tips that I'd like you to consider, and these are based on our experience with people who have struggled in the prior years. So please read the questions carefully. When you write well-reasoned answers and cite the relevant authorities. The part of the test in risk management is to assess your writing skills, because some of the errors that lead to claims out where legal practitioners can't properly articulate themselves in opinions, and we're just trying to also address that. I've been asked in previous years, how do you divide students in the PMT class, but how do you write a legal opinion? And I was surprised, because I would have thought that by the time people reach the stage of where they are being appointed partners or directors in firms, or embarking on their own the journey to practice for their own account, they would have had to set out legal opinions in writing. But be that as it may, if you have even read a legal opinion or memorandum, whatever you want to call it, by another attorney or another advocate, that if you've ever come across one which is well written, you will know what needs to go into it. But if in any event, I think that we should all have read some well-reasoned judgments in our careers, and those will also give you pointers on how you set out a legal argument. Please cite the relevant authorities in your answers. Do not copy and paste from the presentation or from any of the material, because some of the people who have performed very badly in prior years have been punished for that. It's not the type of assignment where you can just rush to put together in the last few hours before the deadline is due and submitted. please put a sufficient amount of effort into this, because it will help you not only to pass this component of the course, but the lessons learned will also assist you in your practice in the long run. So copying and pasting and plagiarizing is just not allowed. When you refer to the LPWIF policy, please cite the applicable clauses. And something else you should consider when you're reading the questions is to look out for the risk management and insurance issues that arise in each question. When you refer please refer to the relevant case law, the statutes, and other authorities. And the whole point of this exercise is for you to demonstrate your level of understanding of risk management and insurance. Good luck with the assignment, and I think that if you put in the appropriate amount of effort, you will certainly do very well. The questions have actually been made slightly easier for you this year, because you'll note that it's 4 questions, and the 4 questions address the 4 main risks in legal practice, and each type of risk is stated there. Got question 1 states cyber risk. It noted straight away what it is you are dealing with. Question 2, meeting the statutory time limits. Remember, it deals with prescription. Theft of funds, professional indemnity claims. It's the same thing. So, if we would just look at question 1, and I'll read it just in case you haven't looked at the assignment yet by the time you get to the session. It reads, the last decade has seen an increase in cybercrime-related attacks on the legal profession. Cyber risks have increased significantly since the onset of the coronavirus pandemic. One of the main types of cybercrime attacks involves fraudulent emails purporting to be an instruction to change banking details of the party or parties to whom the funds are due to be paid. This is sometimes referred to as business email compromise fraud. Draft a legal opinion addressed to a newly established firm. The opinion must, 1, explain the modus operandi of the business email compromise scam. 2, address the regulatory requirements that may be triggered. 3, explain whether or not losses arising from the scam are covered by the LPWIF policy. And you are asked to refer to the applicable clauses of the policy in your answer. 4, address the question whether or not the firm will be liable for losses suffered by third parties in the event that that is the firm, falls victim to the scam. And 5, suggest measures that can be implemented to mitigate the risks and the insurance policies, if any, that apply. This is a very straightforward and easy question. In session 4, we spent a significant amount of time dealing with cybercrime. The modus operandi of this business email compromise scam is set out in the various editions of the risk alert bulletin that I referred you to. It is set out in the 4 cases that are included in also in that part of the presentation. So if you read all those, it will be easy to come up with the modus operandi. The case study that we went through as well is also sets out the modus operandi of the scam. The regulatory requirements were also addressed when we looked at at the cybercrime issue. And just to go back, when you address the question, remember once again to cite the authorities, cite the cases. And in answering this question, we are hoping that you will be alert to the modus operandi, and thus this will help you avoid falling victim to the scam. The question on the regulatory requirements is aimed at testing your understanding of what those regulatory requirements are in relation to the cyber scam. As a start, I think you should consider what Rule 54.14.7 says, what Rule 54.13 obliges you to do, and also remember the rules that relate to shortfalls in trust accounts, the trust account not being in debit, and the obligation on the firm to immediately report the shortfall to the Legal Practice Council, because at the end of the day, the firm falls victim, and these are trust monies that are lost. There will be a trust shortfall. So these, I think, Rule 54.14.8, 54.14.9, and 54.14.10, we covered. And insofar as the third question is concerned, whether such losses are covered by the LPWF policy, we likewise covered that both in Session 4 as well as in Session 6. In Session 6, we dealt with the exclusion from the LPWF policy, but this was also mentioned when we dealt with the matter in Session 4. When you look at the LPWF policy, as I've said in Session 6, look at the definitions, and then go on to look at the exclusions 16C and 16O of the policy. But if you don't know what the definition of cybercrime is, you will have problems. Explain that in your answer. The fourth question relates to the liability of the firm in the event that it's the third parties suffer a loss. Questions of the test for liability of firms of attorneys, has been set out in a number of cases. Those cases are covered, that are referred to in your notes, in the footnotes. Footnotes 21 and 22 will give you the cases that deal with liability. You need to read those cases in order to understand the test for liability of a legal practice. And then also you'll also look at the test in the cases that were referred to in the slides, specifically dealing with cybercrime. Suggested measures and insurance policies. The suggested measures are also covered in detail or in the articles that I've referred you to. But if you read the Jurgens versus Volksschenk judgment, it also gives a number of suggestions. You can, rather than just regurgitate what is stated there, you can also add your own measures that you think can be applied. So we know that when we take into account all the material that we've covered in this module, I think that question should be a fairly easy one to answer. The second question relating to statutory time limits reads as follows. International professional indemnity claim statistics show that a failure to meet time limits imposed by statute is one of the most significant risks faced by legal practitioners. This is also the case in South Africa. It will be noted from the LPWF claims stats, for example, that prescription-related claims make up the highest number and value of all claims notified. What measures can be implemented in a legal practice to mitigate the prescription risk? Once again, prescription was covered in detail in session 4. At the beginning of session 5, the presentation also gave you some suggestions, some material that you can read in order to fully understand the prescription risk and also suggest measures that you can implement. Theft and under-settlements were also addressed in the same material. That takes us on to the next question, the question 3, theft of funds. And if I can read it, misappropriation of funds, whether in the business or trust account, is a significant risk for all legal practices. What measures can be implemented in firms to mitigate this risk? Which insurance policies, if any, are available to indemnify losses arising from the theft of funds? Theft was covered when we dealt with the main risks in session 4. We also covered, provided you with resources at the beginning of session 5. Session 5 also once again reiterated what insurance policies you can consider and what risks they each one of them indemnifies. The measures that you can implement in firms to mitigate this risk were covered in sessions 3 and session 4. Remember when we spoke about segregation of duties and some of the aspects of file audits. So those are just some of the measures that you can look at. But once again, you need to, if there are any, that is what is stated in the presentations is not an exhaustive list. If you have the measures that can be implemented, please set them out in your answers. Please do not just write answers in bullet points. That's not how you write a legal opinion. If you need to expand on a measure you suggest, please do so. Question 4 is relates to professional indemnity claims, and it states that you are a senior attorney and held in high regard by your peers in the profession. You receive an exasperated call from a colleague seeking advice in respect of an emergency in her law firm, ABC Incorporated. She explains that she has received a letter of demand from a long-standing client. The allegations in the letter are that ABC Incorporated breached their duty of care to the client, in that incorrect legal advice was provided to the client, resulting in the latter suffering a loss in excess of 127 million. ABC Incorporated has 3 directors. One of the directors had been instructed in the matter and had been dealing with it on his own for the past year. He has earned a significant amount of fees in the matter and has never allowed any of the other partners or staff to have access to the matter or reported to them on it. A brief investigation showed that the advice given to the client was clearly wrong. The professional relationship between the partner concerned and the client arose from a long-standing friendship between them, and the particular instruction that led to this claim is not recorded in writing in any of the documents available. No notes are kept of discussions with the client. You are requested to draft an opinion for ABC Incorporated answering the following questions. 1. Is the firm potentially liable to the client in these circumstances? 2. If so, is there any insurance policy in place to indemnify the firm, and for how much is it indemnified? 3. What is the test for assessing the liability of an attorney? And 4, what measures can the firm implement to mitigate similar risks in future? Just going through the facts of that case when we consider what was covered in session 6 in particular. There are certain things that should be jumping out to you already. If I go to the third line of the facts, she explains to you that she has received a letter of demand. Remember what I said about a claim, what triggers cover, does go back and listen to follow the presentation to see whether a letter of demand is sufficient to trigger cover under the LPWF policy. Breach of a duty of care to the client. Remember the test for liability of an attorney. The loss of 127 million, that you should be asking yourself. So what is the limit of indemnity and that this firm has under the LPWF policy? And if the claim exceeds the limit of indemnity, what happens? If it has the top up in the insurance, will the ABC, you can ask whether ABC has top up in insurance, and if so, what the amount is. You can explain to them what the limit of indemnity is under the AWF policy, and therefore anything above that goes to top up. The fact that ABC Incorporated, if you ask me what the limit of indemnity is under the LPWF policy, ABC Incorporated has 3 directors. Remember what we said, the limit of indemnities is based on the number of the directors. Something else that stood out for me when I read this is when we go on, we can see in the 4th last line of the facts that the advice given to the client was clearly wrong. A red light will be flashing for me already, because I'm thinking that there's probably potential liability if you give incorrect legal advice. The fact that the particular instruction was not recorded in writing. Do you remember what we said in session 2 about managing the engagement with the client and letters of engagement? No notes were kept of the discussions with the client. Remember what we said about the file notes and file order, and the importance of keeping file notes. So that first question regarding whether the firm is potentially liable to the client in these circumstances should be an easy question for you to answer, and you should also be able to answer why. The insurance policy that is there, a insurance policy in place, and for how much is the firm identified? That is also an easy question when you consider what we covered in the sessions 4, 5, and 6. The test for assessing liability for an attorney, as I've indicated, it's referred to in the cases that have been cited in the footnotes in your manual. What measures can the firm take to mitigate similar risks in future? Yeah, you will need to seriously consider what you've learned in the various sessions. The partner is working on the matters exclusively with no oversight. What about a peer review system? How about file audits in the circumstances such as this? The instruction not being documented. What do you think about a letter of engagement or some other manner of documenting the instruction? File notes and file order also come up. So you'll see that the assignments and the answer to these questions are really practical and rather easy. Thank you very, very much for the time we've spent together, though virtually. Good luck for the assignment. Good luck in your practices, and I certainly hope that there is at least something you have learned in the time that we've spent together, even if it is just one iota of risk management. Thanks very much. And that is the end of session 7. And the end of the module 2.